Hi everyone, welcome to Title 3 of the Revised Corporation Code. We will be discussing the Board of Directors and Board of Trustees and the Corporate Officers. I did not place the provisions anymore, although I will try to the best of my abilities and in the interest of time to read it as quickly as possible or just to point out some important parts. I do expect that you have a hard or soft copy of the pertinent provisions. These are sections 24 to 34 while we are discussing this video so that we can go as quickly as possible. So let's get started. This is a table of the difference between the stock and non-stock. So it's self-explanatory. What is the governing body? There's a different name when it comes to stock and to non-stock. As to number of members, a stock corporation can have one. And governing one person, for one person corporation, up to 15 only, whereas in non-stock corporations, there's no limit except educational institutions. We will talk about educational non-stock corporations, and we will talk about that later when we get to that title. For corporation sole and one-person corporation, obviously there's one. Term is 1 year for stock and 3 years for non-stock, except educational non-stock, which have 5 years. And please note, we will discuss this later on, a term is different from tenure. So just keep that in mind first. As to the qualifications, a member of the board owns at least one share of capital stock for stock corporations or be a member for non-stock. So for those of you who see a page number in red, that's actually just for my reference. Please, no need to memorize that. So let's talk a little bit and quickly about the one share of capital stock. It provides, Section 22 provides that to be elected as a director, one must come from among the holders of stocks registered in the corporation's books. In the case of non-stock, it must come from the members of the corporation. The reason for this rule, meaning the one share or membership requirement, is for the protection of the corporation, because it is a means of knowing who are the stockholders who may participate in the management. Now, if you read Section 22, one of the last parts of the provision, it says there that a director who ceases to own at least one share or a trustee who ceases to be a member shall cease to member of the non-stock corporation shall cease to be a member of the board. This is actually automatic. It does not need to comply with the provisions of Section 27 on removing a director. And we will discuss Section 27 later. Because in Section 27, it's not automatic that the board member is removed. Now, when you talk about shares, there are instances, and I'm sure you'd know this by now, there are instances where a person actually owns the shares but is named under another. What is required under the Revised Corporation Code is legal title, meaning not beneficial ownership. So, for example, in cases where someone wants to be a director but does not have a share, and someone else transfers one share to that person in order to qualify him or her for the position, that is allowed. Now, how about corporations? What if they own a share? Can they be members of the board? They cannot. But a corporation cannot be elected as a director, but a duly authorized officer may be designated as a nominee. Those are most of the instances when a shareholder gives one of its shares to someone else, a nominee, an authorized officer. It's more like a qualifying share. So what if, for example, and there are cases where the assignment gives legal title to a representative. If that assignment is revoked, then it means that the representative automatically ceases to be a director. Okay, for a trustee, meaning someone, and I'm sure we discussed this already. The trustee in a voting trust agreement is also qualified to run as a director. The trustee has legal title over the shares. Okay, unless a person is not unless he is a stockholder in his own right, a proxy cannot be elected as a director. What does it mean? Proxies need not be stockholders. Just be careful. So there's a difference between a nominee and a proxy. Now, there is an SEC opinion, and I just want to share that a person who does not own any stock at the time of his or her election is not disqualified if that person becomes a shareholder before assuming the duties of the office. What is the key word? That the person is a stockholder of record. So an assignee cannot be elected as a director if the assignment in his favor is not yet registered in the books of the corporation. So it means if an assignment is made, it must be registered in the books. There is an opinion by the SEC kasi if you read section 22, it does not qualify between voting and non-voting shares. It says there at least one share. So the SEC is of the opinion that a holder of a non-voting share cannot be elected as a director because non-voting shares cannot participate in the management. So if they are allowed to be directors, then it's like we're circumventing the revised corporation code. So that's how we interpret. The articles of incorporation may provide that a director must have more than one share as long as the required number of shares is reasonable. So that's another opinion. Kasi the one share requirement is just a legal requirement. It's the bare minimum. No one is disallowed from owning more. Another requirement would be that the person is of legal age. Although it is not clearly stated in the revised corporation code, it can be understood because the board of directors or the board of trustees as governing bodies will be entering into contracts on behalf of the corporation. So as agents, they have to be qualified as well. Letter C, they should not be disqualified. We will discuss this later on under section 26. Letter D, it means the required number of members as stated above. Letter E, it means the nationality requirement if applicable. There is technically no citizenship requirement for directors or trustees under the revised corporation code. In fact, foreigners can be elected. There may even be corporations where all the directors or trustees are foreigners. So just take note of that. There are cases where a number of foreign directors is actually restricted by nationalization laws. For example, in nationalized activities under the anti-dummy law, foreigners can be elected as directors only in proportion to their allowable equity participation in the capital of the said activities. So if foreign equity can only be up to 40%, then necessarily their seats in the board should not exceed that 40% requirement as well. What about dual citizens? They can be directors and officers of corporations engaged in partly nationalized or wholly nationalized industries even if they possess dual citizenship. So just know that dual citizens are still Filipinos. So they are not foreigners in terms of their citizenship for corporations as well. Okay, how about other special rules or the bylaws? If it's in the bylaws, the only requirement is that the additional qualifications are just and reasonable. So it's a bit subjective. Let me just go over some special rules. For example, under the General Banking Law, Section 15, there must be 2 independent directors. And under Section 16, the requirement is what they call the fit and proper rule, meaning the Monetary Board of the Bangko Sentral ng Pilipinas will pass upon the qualifications, disqualifications, and they can suspend and remove all directors if they commit or omit an act. But there must be due notice first. They cannot summarily remove that director. Another example is under Republic Act 6713 or the Code of Conduct and Ethical Standards for Public Officials and Employees. Section 7 of that law prohibits a public officer from being employed in a private enterprise regulated, supervised, or licensed by his office unless expressly allowed by the law. So there are times that they are allowed to enter into a private enterprise so long as it's not supervised or licensed by his office. Um, in relation to that, or in a bigger picture, the code prohibits conflicts of interest situations. And I will not delve too much into that anymore. What are the qualifications under the bylaws? That will be covered by Section 46, letter F of the Revised Corporation Code. And let me just go over it quickly for those of you who might not have it right now. 46F, the directors or trustees, qualifications, duties, and responsibilities, the guidelines for setting the compensation of directors or trustees and officers, and the maximum number of other board representations that an independent director or trustee may have, which shall in no case be more than the number prescribed by the commission. So that may be stated in the bylaws. That's another qualification. What if an additional qualification in the bylaws is something that the stockholders do not agree to, and a stockholder is appointed as a member of the board, despite the objections that other stockholders may have with regards to that additional qualification under the bylaw? They cannot waive that qualification. If it's in the bylaws, then that's it. What the stockholders can do is to amend the bylaws so that they feel that the qualifications under the bylaws are something that they agree to. So the qualifications, again, is for the interest of the corporation, as I have mentioned. There are instances where, for example, an additional requirement under bylaws, the SEC considered as a valid provision in the bylaws of a rural bank that a stockholder who is at the same time an employee of that bank is barred from running as a director unless he resigns as an employee. And that's allowed. It would not be acceptable, however, if the bylaws will just provide that the disqualifications are subject to the determination of the directors, meaning the qualifications or disqualifications in the bylaws must be clearly stated. If there is no additional qualification under the bylaws, then we just follow the qualifications under Section 22, the one that we're discussing right now, and Section 91 of the Revised Corporation Code when it comes to non-stock corporations. So what is Section 91 briefly? Section 91 refers to the election and term of the trustees, where they shall not hold office for more than 3 years until their successors are elected. And except for independent trustees of a non-stock corporation vested with public interest, only a member shall be elected as a trustee. Therefore, there are times where a member of the Board of Trustees is not a member, does not follow the qualifications under letter A here of the table that you see in front of you. That's an exception. So just take note, when you look at the qualifications, if it's non-stock, you look at Section 22 and 91. Let me just go over Section 22 very quickly. The first paragraph, that unless provided in this code, the board shall exercise, I just say board because it can mean board of directors or board of trustees, depending on whether it's a stock or non-stock corporation. The board shall exercise the corporate powers, conduct all business, and control all the properties of the corporation. Meaning, the board is the governing body, which is the executive representatives of the corporation. The first paragraph pertains to its functions. The second paragraph we've already discussed as to the requirements, the term, and the automatic, and the requirement to hold at least one share of stock. There is a sentence here: each director and trustee shall hold office until the successor is elected and qualified. Meaning, this refers to a stockholder's holdover capacities. This is different from term. As I mentioned, term and tenure. Now, the third paragraph talks about the board having independent directors when it comes to corporations with public interest, and these are listed under letters A, B, and C of Section 22. Section 22 A refers to those registered with the SEC. those listed in the exchange or publicly listed corporations, and those having assets of at least 50 million pesos and having 200 or more stockholders, each holding at least 100 shares. And that refers that portion about the assets and the shares refers to publicly held corporations. So there's difference between publicly listed and publicly held. If you also look at section 95, mining or oil companies, stock exchanges, banks, insurance companies, public utilities, educational institutions, are also those that are considered corporations vested with public interest. These corporations cannot be organized as a closed corporation. Why am I saying this? Because if under Section 95, it states that the companies listed therein and corporations declared by the Commission to be vested with public interest cannot be formed as closed corporations, then we correlate it, neither can the corporations vested with public interest under Section 22, A, B, and C. They cannot also be formed or organized as a closed corporation. That makes sense. The penultimate paragraph talks about, and the last paragraph talks about independent directors. The rules and regulations governing the qualifications, disqualifications, voting requirements, term and term limit, and the maximum number of independent directors will be classified or will be subject to the prescription of the SEC. So the SEC is given more power when it comes to this. Reading the entire provision, the board is, as you can see, is responsible for corporate management. They are the executive representatives of the corporation, and following the primary rules of attribution or the attribution of knowledge, similar to partnership, notice to the board of directors shall also be deemed notice to the corporation. The corporation is deemed to have been given constructive notice. Please note that there are some instances under the law or rules where a particular officer or employee must be given notice before the corporation is deemed to have notice. It not necessarily the board. For example, in the rules of court, summons must be given to the list of officers stated therein, not just to any member of the board. Knowledge of an act is properly attributed to the corporation. It does not follow that all the stockholders are deemed to have knowledge of the same fact. Just take note of that. Katanungin sa quiz. I have already discussed this. Independent directors are these types under Section 22. Just please add the ones under Section 95, as mentioned earlier. So this is the definition, and it is also stated in the provision. The definition of an independent director under Section 22 is substantially the same as that under the Securities Regulation Code. I just want to mention in passing that under Section 38 of the Securities Regulation Code, also entitled Independent Directors, it added another thing. It said here that at least 2 independent directors are required for corporations that are listed in the stock exchange, publicly listed or publicly held, or they shall constitute at least 20% of the members of the board, whichever is lesser. So I just want to add that, just in case. As to the election and qualifications of independent directors, please cross-refer this to Section 179, letter M. Under Section 179, letter M, the SEC shall have the power and authority to prescribe the number of independent directors and the minimum criteria in determining the independence of a director. So that is the Securities Regulation Code, Section 38, which I just mentioned. The reason why there is a need for independent directors is because of their expertise, independence, and experience on the industry the corporation is operating under. And they are unhampered by day-to-day involvement and self-interest. Under SEC Memorandum Circular Number 9, Series of 2009, a regular director, regular not independent, who resigns or whose term ends on the day of the election shall only qualify for nomination and election as independent director after a 2-year cooling off period. Persons appointed as chairman emeritus or ex officio, directors or officers or members, or appointed in a capacity to assist the board in the performance of its duties shall be subject to a 1-year cooling off period. Another SEC Memorandum Circular in 2011 states that an independent director can run for a period of 5 years, and then there must be a 2-year cooling off period before it can be nominated and elected for another 5 years. After that 5-year, 2-year, 5-year mark, they are perpetually banned from being an independent director. It is during the annual stockholders or members meeting that independent directors are elected. So it is not correct to say that it is either the majority or the minority which has the burden to elect independent directors, since to do so would be against the revised corporation code. It is the stockholders themselves who will elect independent directors. There are a number of rules when it comes to corporations vested with public interest. Let me just dictate them. There are 9. These are under Section 22. This provision that there must be an independent director for corporations with public interest, vested with public interest. Number 2, that the right to vote through remote communication or in absentia may be allowed even if it is not stated in the bylaws, and we will discuss it again when we get to Section 23. Section 24, there must be a compliance officer elected by the board. Section 29, there is a requirement to submit to the shareholders and to the SEC an annual report of the total compensation of each director. Section 31 governs the requirement on self-dealing directors, where material contracts shall be approved by at least 2/3 of the entire membership of the board, with at least a majority of the independent directors voting to approve the material contract. So the independent directors have its own requirement aside from the 2/3 membership of the board. Section number 6, under Section 91, for non-stock corporations, these independent directors need not be members. For Section 95, it cannot be incorporated into a closed corporation. Section 176, the Congress may set maximum limits for stock ownership of individuals or groups of individuals that are related to each other by consanguinity, affinity, or close business interest when it comes to corporations vested with public interests. This is to prevent anti-competitive practices. And lastly, under 177, in addition to the repertorial requirements applicable to all corporations, the corporation vested with public interest must also submit to the SEC a director or trustee compensation report and appraisal or performance report in the standards or criteria used to assess each director or trustee. Section 176 provides for the different factors that will be considered in determining which entities will be considered as corporations vested with public interests. And these will be determined by the NEDA, or the National Economic and Development Authority. So I've already mentioned, Board of Directors was created for the purpose of concentrating power to a small group. They enjoy a certain level of independence, which we will call the business judgment rule. So what is this independence? Stockholders do not control the directors. unless stated in the revised corporation code, the articles, and the bylaws, they cannot reverse the decisions of the board. Although they are not entitled to meddle with the decisions of the board, they are not entirely helpless. No? They can remove or elect a director. That's why they have to be very careful. So what is this business judgment rule? Under this rule, the will of the majority of the board controls in corporate affairs, and contracts intra vires, meaning not beyond their authority. So this is the opposite of ultra vires. Contracts intra vires with authority are binding, and the courts will not interfere unless they are uncontrollable and oppressive. So it's on a case-to-case basis. This is so that the courts cannot meddle too much into corporate affairs. Even if there was mismanagement resulting in corporate damages, directors will not be held liable in the absence of bad faith. Syempre, because when a board makes a business decision, it does not necessarily mean that they guarantee success. So what are the requirements for the business judgment rule to apply? The presence of a business decision, it must be intra vires and must comply with procedural and substantive requirements by law. It must be done in good faith. There must be due care in making the decision, and the director must not have personal interest or must not be self-dealing. So you don't need naman to memorize that. I just wanted to know. How do they act? They act as a body. Otherwise, meaning if they don't act as a body, it may be objected to. But if it is not done, if a corporate act is not done by the board of directors as an entire body, it does not necessarily mean that the contract is not binding, because whatever is done may always be subject to the ratification of the stockholders. Now, as to the vote, there is no proxy or alternate directors, and they act through a resolution. For example, and the evidence of the evidence of a resolution is usually through a secretary certificate or the minutes. Unless the articles of incorporation or the bylaws provides for a greater majority, a majority of the number of directors as fixed in the article shall constitute a quorum for the transaction of corporate business, and every decision of at least a majority of the directors or trustees present at a meeting in which there is a quorum shall be valid as a corporate act. So when you talk about approval of a resolution, first, you look into the articles of incorporation and the bylaws in determining what will constitute a majority for purposes of quorum. And then, once there is a quorum already, then the majority of those present must vote for the approval of a resolution. So we will discuss this later on when we go to section 52. When you see here that there's no proxy or alternate directors, this is also discussed under section 52. They cannot attend or vote by proxy at board meetings. A director cannot even delegate his powers as director to another person. Therefore, an alternate director who will act as a director is unacceptable. You will see this under section 22. Now, let's go to term versus tenure. Term has acquired a definite meaning under jurisprudence. It means the time during which the officer may claim to hold office as a right. Why is it a right? Because it's under the revised corporation code. The tenure, on the other hand, represents the period during which the incumbent actually holds office. So these apply to cases where the members of the board are in a holdover capacity. Their term is the same, but the tenure is extended. Conversely, it can be that the term is still 1 year, but their tenure is shorter. For example, retirement, illness, or death, or removal. Yan, that's shortened tenure naman yun. Please note, and this is tricky, incorporating directors or incorporating trustees are not subject to the 1 year term or 3 year term period. They shall act only as such, and they shall act only as incorporating directors until the first regular directors are duly elected and qualified. In fact, the election of regular directors may be even counted as an act that satisfies the requirement that the corporation must organize within a period of 5 years. If you remember your section 21. What if there is a current or a pending case regarding the election of a new director? What if the election of the new director is questioned for being irregular? And during the pendency of the case, another board meeting was held kasi naka 1 year na. What happens then? Then the issue is already moot in academic and that director has to submit to the yearly election. He can't say, oh, because of the pendency of the case, my term was not yet up. No. Once there is already a new election, then they have to concede already. The same rule applies even if the directors were subsequently declared to have been invalidly removed. If there is a subsequent valid annual election, they cannot say, oh, I need to continue because I was already, because the court already said that I was illegally removed. No, that's not true. Once the directors have no right to continue as a director unless re-elected. If you're not, sorry. Let me just clarify more about quorum, no? There's this board question in the 1970 bar where the board of directors of a corporation consists of 9 members, 2 having died during their term of office, and 1 being abroad. What would be the quorum? The answer was 5. The revised corporation code provides that a majority of the number of directors as fixed in the article shall constitute a quorum. So, if in this case the board constitutes 9 members, then the quorum must be the majority of 9 or 5. What does it mean? We don't care if 2 died during their term of office or 1 is abroad. Vacancy does not constitute quorum. Vacancy does not reduce the quorum. If 5 members are present, then we have quorum. The majority of 5 or 3 may pass a resolution unless a greater number is required under the revised corporation code. Let me just add, although this is unnecessary, and I'm sure you know this, a director or a trustee must be a natural person. I've already said that already. Inuulit ko lang. Additional qualifications under special law, I've already mentioned this. Other points, I forgot to add it on the other points, but ex officio members, and I've mentioned it a while ago, you might be wondering what they are. A person who is not a stockholder in a corporation governed by the revised corporation code cannot be a director, but he can be an ex officio member of the board without voting rights. So, under Republic Act 10149 or the GOCC, Government Owned and Controlled Corporations Governance Act, it provides for ex officio board members or alternates in GOCCs. So, an ex officio board member refers to any individual who sits or acts as a member of the board by virtue of one's title to another office. Meaning, there are some instances that as because of having held or because of holding a position in a certain canary in government, then they become ex officio members of a GOCC. They may designate their respective alternates and there is no more need for an appointment. Alright, so let's continue. As the effect of disqualification, a disqualified stockholder cannot run for election as a director. The subsequent disqualification of a director will not render the board incapable of transacting business as long as the remaining stockholders constitute a quorum, like the one I mentioned about the answer in the 1970 bar. No one is prevented from seeking re-election unless it is stated in the Articles of Incorporation or Bylaws. Remember, the articles and the bylaws can always add more qualifications. Okay, what is holdover capacity? I mentioned it a while ago. Please read section 23. We will go over this again in relation to section 25. Excuse me. Sometimes holdovers, while it is not encouraged, it cannot be avoided. No, it's inevitable. However, once an annual stockholders meeting takes place and new directors are elected, the old directors cannot continue to serve as directors. So the holdover principle cannot be invoked as a shield to perpetuate office, to perpetuate oneself in office. After the annual election, the old directors cannot serve in a holdover capacity, even if the latter were previously illegally prevented or enjoined for performing their functions during their term. What does it mean? If there is already an annual election, the ones who are elected in the annual election are illegally prevented or enjoined from performing their functions, the old directors cannot just use that as an excuse to perform holdover functions. The holdover period is not part of the director's original term of office, nor is it a new term. It is part of his or her tenure. The purpose of a holdover capacity, even if it's not encouraged, is a means to continue the operations of the corporation. Remember, a corporation is a going concern. We don't want the business operations to be hampered just because the 1-year period is already up and there was no proper election held yet. Before we move on to section 23, I just want to read one question given in the 1984 bar. At the annual meeting of ABC Corporation for the election of 5 directors, A, B, C, D, E, F, G were nominated. A, B, C, D, E received the highest number of votes and were proclaimed elected. F received 10 votes less than E, so he was the 6th. Subsequently, E sold all of his shares to F. At the next board of directors meeting following the transfer of the shares, both E and F appeared. E claimed that despite the sale of his shares to F, he still remained a director. Because it says here that directors shall hold office for 1 year. So the word shall means it's mandatory. On the other hand, F claimed that he would have been elected as director had it not been for E's nomination. So he should now be considered a director because he acquired the shares of E. What F was trying to say is, since E is already disqualified, I got the next highest, I got the 5th highest vote, then I should be a board of director. And the question required the bar candidate to decide. The answer is E is disqualified because he does not have a share, and F cannot be a director because a board member must be duly elected. He was not elected as a director because he lost. The fact that he later on became disqualified does not change the fact that he never won in the first place. Yeah. So let's continue to section 23.